There are multiple types of custody, and they mean different things. Joint legal custody is the most prevalent type of custody. And what that means is two parents have an equal say in major decisions of the child's life, health, education, welfare. Think of that overview. That's the primary custody. Then you have sole custody. Sole custody means that one parent has been charged with the decision-making for all health, education, welfare, or some health alone issues concerning the child. Those two custody designations, joint legal and sole, have nothing to do with parenting time. That is simply decision-making authority. When you're talking about parenting time, then you're just talking about time sharing. And it goes back to this concept of choosing days of the week and hours on the clock. The common misconception is that we have to be designated the sole custodian to have primary parental designation. And that's not correct, because that's simply decision-making. When you choose days of the week and hours on the clock, then we can decide who's going to be the parent of primary residence and who's going to be the parent of alternate residence. In New Jersey, those designations are primarily associated with the child support calculation. Many people misjudge those to be the designations of parenting time, but in fact, those are child support designations, not parenting time designations. So joint legal is your primary determination for custody, unless there are some extraordinary circumstances that would make one parent the sole custodian for decision-making only. When you're determining the custodial designation, the court and counsel, the mediator, anyone has to consider what's called the best interest of the child. And there's a number of factors associated with that determination. When we look at the best interest of the child, we look at the ability of one parent to make decisions on behalf of the child that suits their needs. And one family's best interest is not going to look like another family's best interest. If you have a child who's been diagnosed with autism or some other diagnosis, that best interest analysis is going to look very different than a family who has a child who's more mainstream, but maybe into a lot of travel sports. That may be a whole other determination of best interest. So we look at these factors and we look towards which parent has historically made these decisions and which parent can predictably make those decisions going forward to meet the child's needs as had been established during the marriage. When we look at designations of custody and determinations of joint legal versus sole legal custody, we look at a list of factors. These factors, when you actually put pen to paper and put your family's customs and dynamics into this set of factors, you're going to find that most of the time they are not helpful in helping you as a family to decide what's best necessarily to do. These are factors such as who has historically made these decisions? What is the stability of the home environment being offered? What is the ability of the two parents to communicate? What is the ability of each parent to foster the relationship of the other parent? When you're in the middle of a breakup, all of these factors seem very difficult to nail down, right? We may not know where we're going to be living and whether or not we're going to be next door neighbors. Right now, there could be some claims of domestic violence, although it's the first time ever they've been made. Right now, we may not have a good communicating relationship. We may not want to call each other and, ask who's picking Johnny up at baseball. So we look at these factors through the prism of the context of the day. When I look at these factors, however, to apply them, I like to look backwards at how did you actually live, and I like to look forward at how do you plan to live 5 years from now. Because to me, today is a snapshot of probably the worst, and the goal is that it gets better. So I want to move your family to the snapshot of these factors applying in positive light going forward. Once you have agreed on a custody and parenting time plan and or designation, right? It'd be a custody designation, a parenting time plan. Or once the court has ordered either or both of those in a final decree. In order to make a change to that designation and or plan, you have to prove a substantial change in circumstances. This is really important. Before you get divorced or before you set an order in place, a final order, you're considered equal, right? Two parents are considered equal in New Jersey when you start this conversation. Once you set your plan, then the plan might look like a little disproportionate this way, it might look a little disproportionate this way, or it might be equal. To change this plan, the disproportionate or what could be equal, you have to come in and explain why now that decision is no longer good and that it's so bad right now that it is substantial. So it's not just, well, now I have a new job. You could have planned for your new job 3 years ago, or the thought that you were going to have a new job. That's not a substantial change in circumstance. You could say, well, yeah, but now my child is 5 and in kindergarten, and when I did the plan, the child was 2. Well, you knew your child was going to turn 5 and go to kindergarten. That's not a substantial change in circumstances. So when you're building these plans, it's really important that you consider the today and that you consider tomorrow, because your child is likely going to age. You are likely going to find a new relationship, new home, new family, new marriage, maybe more kids. There's a possibility one of you is going to move out of the state, especially if you are in the military or if you are in a religious community that encourages travel. You want to plan for those eventualities, because changing your custodial or parenting plan does require a rather high threshold. It is not impossible. We do it all the time. But we do require, before we allow you to retain us, that you tell us exactly what you believe those substantial changes are, because we don't want to go forward and give you a false hope. So make sure you're planning ahead when you're making these decisions. For many families, custody is going to be the most important decision you make. It is important that you make the decision for today and for tomorrow. And that when you're making these decisions, you avoid being sucked into the emotion of this debate. It is far more important that your child know you, that you know your child, and that you can help to raise your child, which was probably your intention when you made the decision to create this family.